the Genesis Innovation Workshop on Monday, the 14th of December, focusing on Brexit and beyond and the immigration laws. So this will be a presentation shown by Meghan Vozila, Senior Associate at Penningtons, Manches. So she will go through the update and what everyone needs to know in terms of recruiting staff from overseas, especially from the European Union after the UK leaves. And of course, I will be open for questions. So anyone having a question, just dropping in the chat box. And then obviously the meeting being recorded, you can always watch it later or share with colleagues who may have interest into that. So on that note, Meghan, over to you.
Hi. Thank you for that introduction. Welcome everybody. Thank you for joining us. I'm going to take you through kind of a whistle-stop tour of the new immigration rules that we've just received on the 1st of December, together with some provisions that are in place for European nationals who get to the UK before the end of this month, and just sort of the compliance requirements of employers who sponsor workers under this new system going forward. I'm going to try to keep the presentation to about 45 minutes today, to leave 15 minutes at the end for questions and answers. If you just type questions into the chat box, what I'll do at the end of the session, I'll stop sharing my slides and I'll take a look and we'll start going through those questions. So I guess first, just to give you an overview again of what we're doing today, I'm speaking initially about European nationals, people who are already here, what steps employers or individuals can take, and what steps their employers can do to determine and to ensure that their staff are able to continue to work in the UK post the end of this transition period, since the UK left the EU in January. I'll talk to you about the new immigration rules, primarily focusing on the skilled worker route, though I'm going to give you an overview of other routes that are available. The skilled worker route, just as that's going to be probably the most utilized route for employers and workers who are coming to the UK. And then I'll talk to you about the sponsorship duties, the kind of cost of that ability to bring workers from outside the UK. So let's get started. EEA Nationals European Settlement Scheme. This is the scheme that the Home Office has introduced, the government here has introduced, to protect all of those European nationals who are here and exercising treaty rights before the 31st of December 2020. Though we've left the EU in January of this year, European free movement rules continue, and they'll continue until 11 p.m. on the 31st of December. So any European national who arrives before 11 p.m. And crucially becomes resident in the UK. So that's a question later on, particularly for those who are arriving just before the deadline. They will have until the 30th of June to make applications under the EU settlement scheme to acquire an immigration permission to replace that European right that they had up until the end of this month. Family members include civil partners, dependents who are in the ascending and descending lines, so parents and grandparents and children and grandchildren. All of those people will benefit from the EU settlement scheme so long as the relationship exists before the 31st of December, and they then later join the European national in the UK. Crucial thing to remember, Irish nationals don't have to apply. There are separate provisions that differentiate, through the Good Friday Agreement, differentiate the status of Irish nationals. They have the option, but don't have to apply under the European settlement scheme. And another group that I think sometimes don't realize they need to do anything are those who hold permanent residence under the European route. They also will need to apply. They can switch into what's called settled status, which is the higher status we'll talk about in just a minute here. So what are the consequences for missing the deadline? We still have in the UK what's known as the hostile environment. It's been rebranded in the last year or two to the compliant environment, but it is the system which requires employers to check the right of work of anyone who they employ. The NHS has to check that people are entitled to treatment. Landlords have to check that the person who wants to rent their flat is entitled to live in the UK, and all of this is going to apply to European nationals. So if they haven't applied under the European settlement scheme, they'll either have to qualify into the new immigration rules that we'll talk about in a minute, or they won't be able to stay in the UK, they won't be able to work here. Family members may also need to leave if they haven't acquired status in their own right under some other provision. And if they're not able to qualify under the new rules, they may not have an option to remain in the UK. So what we'll get to in a few minutes when we talk about the skilled worker route is that there is a cutoff, there's a baseline level of skills that a worker needs to hold in order to be sponsored. And certain roles may not be eligible for sponsorship, and that would preclude people who are in those roles, if they're European, from continuing to work and live in the UK. And again, those with permanent residence, if they haven't applied, even though they've held permanent residence, which was a right to reside here indefinitely, if they haven't converted that status, if you will, to European settled status, they too would have to leave the UK unless they could qualify in the new rules and restart their clock actually to obtaining settled status again. One thing to note, Swiss nationals, so family members, if a European national is in the UK already and their family member isn't, so long as that family member, that relationship was in existence before the 31st of December, or in the case of a child, if the child was born after 31st of December overseas, they would have an ability to qualify under the European settlement scheme even after that deadline passes. And Switzerland has its own independently negotiated arrangement with the UK, which actually extends that period to the 1st of January 2026. So any relationship that comes into existence before that date, a marriage or a civil partnership or something like that, those individual family members, if they weren't European themselves or just simply didn't qualify for settled status in their own right, they could apply as the family members of someone who does. So how does the system work? It's actually an online, totally electronic system. The status also given is electronic. It isn't in a document for the European themselves. It's an app that's downloaded into the phone called the EU Exit ID document app. That app is used to verify the identity of the applicant. So they'll scan their passport, it unlocks the chip, using near-field communication in the phone. The app unlocks the chip in the passport, which extracts the biometric information in that passport that's held. And then there's a face scan and a photograph that's taken and then cross-checked. The biometric reference point on the face are cross-checked against the passport to determine whether the applicant who is presenting that passport is the person who actually is the holder of that passport. Provided those checks come through satisfactorily, then the online app actually takes you to an online application. This gets confusing when we start talking about this to poor clients that can't, talking about the ID app and then the online application. But in the online application, that's actually where background checks are made automatically by the system. And if certain information is gathered from those background checks, the status can actually be issued automatically as well. So generally, the system is looking for residence. It's just looking for physical presence in the UK. That can be established by using the national insurance number, which the application asks for. Background check is made against DWP and HMRC. If that person's national insurance number shows up within the last 6 months, they would be granted status as a pre-settled applicant. If it shows 5 consecutive years hits in the system, then settled status can be granted. There are considerations though, because the online application system isn't sufficiently smart enough or sophisticated enough to catch this. But residency in the rules means for settled status means that the 5 years the person is here has to be a continuous period of residence, where 6 months can break, an absence of 6 months in any 12-month period, that's a rolling calculation, can break that continuity with some limited exceptions, and those are listed here. So the app doesn't actually question ask the applicant the question, have they been in the UK continuously for this period? It's part of a declaration that assumes the person knows all of these nuances in the rules when they hit yes, submit, and sign the form electronically. So it's something to keep in mind. What also applicants should remember is that it also checks against the criminal records database system for their details, and there is a criminal records check. It is not as onerous as the visa application process yet. So things like a series of traffic violations, those sorts of kind of low level convictions wouldn't affect an application, but more serious crimes could affect the outcome of an EU settlement scheme application. Apologies, I've got a bit of a cold, not COVID, so if I start coughing here, I've got my water ready, and just bear with me. So I've kind of gone through this already, but you've got two options, and the app will, at the end of the application, present these to an applicant. Either it will find them in the system for a consecutive 5-year period, and it presumes that they've been here continuously during that period with no breaks of 6 months absence, and it will offer settled status. And then, the applicant says, yes, please, submits the application, signs the declaration electronically, and a few weeks later gets a result. The other option, if 5 years evidence isn't automatically found through a background check, it will present pre-settled option to the applicant, and they will have a choice of accepting pre-settled status if they know they haven't been here for 5 years, or disagreeing and then uploading further evidence to establish their residence here. The evidence is rather broad. The government does provide guidance on this, and they are quite generous in the documents they'll accept. Bank statements, for instance. I'm sorry. Council tax, letters from employers, GP records, all of these things, school records for children, will count towards or be accepted as evidence of residence in the UK. So after the application is submitted, and if necessary, documents are uploaded, a caseworker will look at this application and issue a final decision, which is sent by email. The letter just attached to the email, and that's the evidence of the decision that they have. It's not evidence of a right to work or live in the UK. That's done via online checks that I'll get to when we start speaking about the duties and obligations of employers when taking on foreign national workers in the UK. Once, oops, sorry, didn't mean to flip through that quickly. Once settled status is granted, so that point that 5 years residence is met, it can only be lost through a continuous period of absence from the UK of 5 years or more, where pre-settled status is a grant of 5 years to get you to settled status. And if you leave the UK for more than 6 months during that time, continuity is broken. But if you return within 2 years, you can at least use the remainder of that pre-settled status. It's a bit confusing, and I think it may catch out some people who think they have up to 2 years ability to leave the UK to still qualify for settled status, where actually they only have 6 months. So it's something to be careful of. Now there's an interesting dilemma in the system, I think, that's partly caused by a 6 month grace period, rightly granted by rightly requested by the EU when negotiating. I'm sorry, guys. I will get through this. When negotiating the end of the transition period. And what it has created is this period that, you know, between the end of the transition and the 31st of December, European nationals have up until June to apply for status. So in the first 6 months of the new year, immigration officers, employers will not be able to differentiate between those who've entered the UK and resided here before 31st of December and who are entitled to status under the settlement scheme, and those who haven't. So the first 6 months of next year, nothing further than an EU passport and an identity card will be required to take work in the UK, to enter the UK at port, or to rent, to open bank accounts, to access the NHS. We would advise that people should always carry proof, particularly those who are entitled to settled status, especially when traveling in and out of the UK, to show that they either have already acquired settled status or that they're entitled to it, and we'll be making that application before June. And I'll give a few examples here. Evidence of that first entry to the UK, if it was, you know, just before the 31st of December, or correspondence from an employer confirming that they've been working in the UK before the 31st. That was kind of a whiz-bang coughing tour of the European settlement scheme, but just in the interest of time, I want to make sure I get through all of the slides. So to take you into the new immigration rules, these are what are replacing free movement, modifying what was in existence before the end of the transition period for people outside of the EU, and for sponsoring workers from outside the EU, and what will come into force from the 1st of January for all European nationals as well. So it will apply to everyone, they say equally, but then question that odd 6 months we have in the first part of 2021. And it will apply to every European national who comes in after the 1st of January. In essence, what the government envisages is that it will all foreign nationals will be treated equally. A European national, just as a US national or Indian national, will have to meet certain qualifications to enter the UK to work and live here. What we have done, we had a tier system for those of you who are familiar with the old system, which was tier 1 to 5 of skilled workers, tier 1 being the highly skilled, till that, you know, independently didn't require employment, tier 2 being the employment category, 3 never actually operating, 4 were the students, and 5 were the temporary workers. We've obliterated that, though we've retained many of the categories in the new system, as you'll see. It's still a points-based system. Those who had sponsor licenses under tier 2 or under tier 5 will continue to have their licenses. Those will be automatically renewed. Sorry, I'm getting further supplies here for this cough. Those who have existing sponsor licenses, those will automatically become skilled worker licenses. As you'll see, there'll be more flexibility. People used to have to, at the expire, if they wanted to switch from one category to another, would often have to return to their home country to apply for a new visa to then return to the UK. There's more flexibility on that. People can now, there's more categories that are able to switch from within the UK without having to return home to apply for new grants of leave. And one difference with the new system is more the tech, as the UK is trying to move the immigration system more to more electronic means. They've retained this online ID checking system for European nationals. So instead of having to go to centers they have photographs and fingerprints taken, they will now be able to use a phone to scan their faces and unlock the chips. So those are kind of the main headline provisions. The system has actually opened since 1st of December to all non-European nationals. And so sponsors are already sponsoring new workers coming to the UK now under this new system. And then in line with the end of transition period, it will become mandatory for European nationals to qualify under that as well if arriving in the UK for the first time after January of next year, after 1st of January. So sponsorship in a nutshell, kind of a 4-stage process. Some of you may already hold sponsor licenses. Stage 1's already taken care of. But you've identified a worker, you hold a sponsor license, you now have to review the role that you want to offer that person and the person themselves to identify whether the role is suitable and the person is suitable for sponsorship before you assign the certificate of sponsorship, the COS. The individual then applies for the visa, either overseas or in the UK, depending on what their current status is. And then once the application's approved, they can generally start working shortly after. What has been a recent welcome development, there's been some acceleration on processing times around the application for the sponsor license, where they used to take 8 to 12 weeks to process a sponsor license. Those applications can now be expedited, and consideration can be given within 5 working days. The certificate, we'll get to the 2 types we have. Generally, if the sponsor either has an allocation of certificates or they can request what's called a defined certificate, those should come through within about, the Home Office aims, and at the moment is processing those applications within about 24 hours. I think there might be some delays in the future, but generally within a few days, you've got the certificate of sponsorship. It takes about half an hour to assign it. You sign through the sponsorship management system, which is the online interface the employer sponsor has with the Home Office. And then you give that certificate electronically to an individual who applies for a visa. The visa application process generally takes about 3 weeks, depending on which overseas post or whether they're in the UK. 3 weeks is kind of the standard process, but it can be, again, expedited to either 5 working days or one next working day basis for additional fees. So in essence, if there's a really urgent need, of course, there are additional fees to be paid on top of the normal filing fees. I'll get to those in just a few minutes on another slide. You could theoretically have someone in position from the point of applying for a sponsor license to them actually starting work within a few weeks. This has been a welcome development because previously it could take up to 3 months on average for an employer, once a person was identified, to actually have them in post if the sponsor didn't already have a license. So kind of the basic requirements for sponsorship is to check that the role is sufficiently skilled. So you have to assess the job duties and job title against Office of National Statistics SOC codes. Those are standard occupational codes created by the NHS, the ONS, to attempt to categorize basically every permutation of role that could be undertaken in the UK to about 8,000 codes. So it's not an exact science. It's normally picking the one that looks most suitable as opposed to the perfect code. And those codes, set out what the minimum salary thresholds and what the minimum skill level is for that role. And then just to talk about these 2 types of certificates that are available, cleverly named defined and undefined certificates. A defined certificate is the certificate you must assign to anyone who's not in the UK at the point that they would be applying for the visa. where the undefined certificate is available by allocation. So sponsors get these in a yearly allocation cycle. And they can be assigned to any individual who's already here. So someone who's maybe working for someone else, or a student who is graduating and wants to take up a role. Those are the type of people who would be eligible for undefined certificates of sponsorship. I think what I'll do is just kind of give you a cross comparison of the old system versus the new system, just to understand how it's been relaxed, and how this new system will work. For those of you who are already aware and familiar with Tier 2 General, what was in place before the 1st of December, the quota that we used to have, that used to, what the defined cause used to be known by, was a restricted certificate. That's been abolished. So, well, suspended, not abolished. So they may bring it back. They're watching this, but for the time being, there's no limit on the number of people who can come into the UK from overseas to work. They've also crucially abolished the resident labour market test. This was the advertising campaign that used to have to be undertaken before you could even offer a role to someone who wasn't British, to test the British workforce, to ensure that no applicant came forward that was suitably qualified and already permanently resident in the UK. It creates an interesting problem, which we'll get to in a minute, on this idea of a genuine vacancy, but also what we've spoke to a little bit previously was that there's been this enhanced flexibility on switching in country. People are able to apply to change categories while they're still in the UK, and qualify into the skilled worker status. There's been some slight reductions on the minimum salaries that need to be paid to skilled workers. You can see just a small 300 and a bit decrease to those who are qualified as new entrants, so people who are recently graduated or under the age of 26. But what's been removed is allowances. So previously in the old system, allowances, housing expenses, cost of living allowances, those used to be included where they can't anymore. So question whether the salary has really been reduced that much. Also, it's important to note that the minimum going rates, the minimum salary is either these minimum salary requirements, or what's the stated minimum on this standard occupation classification code that most appropriately suits the role, and those are often much higher. So just keep that in mind. There's no cooling off period. This was the period previously under the old system, where someone who'd been here as a Tier 2 worker would have to wait 12 months after their visa expired, if they were overseas, to return to the UK as a skilled worker. That's been abolished, as has the maximum period of sponsorship of 6 years, where previously you could only sponsor someone for 6 years straight. You can now sponsor them for many more if they need it. But it does, the category still remains a category that leads to settlement after 5 years. So those are the main changes. The skilled worker category is still a points-based system for those of you familiar with the old system, and still requires 70 points be met. I say points-based system slightly tongue-in-cheek because, as you'll see, and I'm sorry, I'm going to speed up a little bit just to get through the slides. As you'll see here, we have mandatory criteria and then tradable options. 50 points mandatory, so that leaves us 20 points that are tradable. And you'll see that you only get 20 further points if either the salary is at that minimum threshold, or in very limited circumstances, the salary can be under. So the only real tradable section of the skilled worker route is on the salary. Otherwise, you have to meet all the criteria, and it's not quite points-based. So if the role attracts a salary of less than the 25,600, then, or at least that going rate for that particular code, you can then look at these options to see if you can rely on a lower salary. There's 2 options for PhDs, as you can see there. If it's a STEM, if the person holds a PhD relevant to the role, you can pay 90% of that going rate. But if it's in a STEM subject, the going rate level drops to 80%. Shortage occupations, you're able to pay less, as well as to new entrants. These are the the young graduates, recent graduates from university. And then the healthcare sector. This is the health visa that you may have heard of in the news to enable the NHS to recruit more workers to plug kind of some of the shortage gaps that they have. And it also applies to the education sector, particularly to teachers of mathematics and STEM subjects, where there has been a chronic shortage recently. So assessing genuine vacancy is one of the crucial parts of this of sponsorship, and it's also a rather difficult. It's not a tick box exercise. It requires quite a few documents to be kept and records to be kept to show how you recruited a person. But generally, what the Home Office is trying to do is prevent nepotism and roles that have been created for the purpose of bringing someone to the UK rather than something that is genuinely needed by a business. There is an English language requirement for skilled workers. It's level B1 of the Common European Framework of language qualifications. It is kind of, well, as you can see, about A-level English, because these are the 4 ways that one can meet this. They're either a national of an English-speaking country, so Australians, Canadians, US nationals would meet this. They have a degree taught in English either in the UK, where it's automatically deemed to have been taught in English, or if it's overseas, this UK recognition system called UK NAR can determine that, and for a fee will provide a certificate. For people who've studied in the UK, they can also use GCSE or A-level English qualifications to meet the requirement, or failing those, pass an approved English language test. There's also a financial requirement. What used to be £945 the applicant must hold in a bank for what was 90 days has been changed to £1,270 for 28 days, or they can continue to be certified by A-rated sponsors. So it's a tick on the certificate of sponsorship when assigning, which is basically the sponsor giving an undertaking that they'll give them a salary advance to that level in their first month employment to prevent them from needing to recourse to public funds. Those who've been in the UK for 12 months, they're deemed to automatically meet the maintenance, that financial requirement, and don't have to prove or reprove it. It's the same with English language. Once you've proven it in one application, you don't have to reprove it again, which is a change, a welcome change from the old system. Still leads to settlement after 5 years, as long as the person hasn't been absent from the UK for more than 180 days in any 12 months during those 5 years. Sponsorship has to continue, and they have to take this Life in the UK test and generally be a good person, no breaches of immigration rules or criminal convictions. And it's crucial to note that if they've been here as a Tier 2 worker, that can count towards the 5 years. I'm going to very briefly touch on costs because they are creeping up. The license application fees have remained the same, £1,476 for companies deemed to be large, or $536 for those deemed to be small in the Companies Act regime. But you can see that the actual cost of sponsoring a worker can become quite significant with the skills charge and the immigration health surcharge. And it can get, if you've got a family coming, you're looking often at tens of thousands of pounds with all of the charges if you've got a family of 4. So it can be quite significant and something to bear in mind. I'm now going to go very quickly through the other routes. We have the ICT route, which is, the intra-company route, which has replaced ICT under the Tier 2 regime. There haven't been real substantial changes to this route. I think that the main advantage of this route over the skilled worker route for an employer is that there's no English language requirement. But as you can see, the skills threshold remains at level 6, which is kind of bachelor's level degree skills required, as opposed to the skilled worker route, which is dropped down to level 3, which is roughly the equivalent of A-level qualification. There has been this flexibility in switching in country, and there's been a drop. We still have the cooling off period. It's been tweaked to make it slightly more flexible, and workers can still be sponsored for up to 9 years at a slightly lower salary. Well, at a lower salary than before. But again, it's not a category that leads to settlement. So I think it's a very second cousin to the skilled worker route for most employers and employees. So what other routes are there outside of the skilled worker IC intercompany routes? There are quite a few. I'm going to give you just bullet point summaries of each so that you're aware of them. But I don't think that they will be utilized nearly as much as the skilled worker route, what used to be tier 2, and the intercompany route, which used to be tier 2 ICT. The global talent route is probably the most attractive to many in the life sciences sector, because it is for those who are kind of at the top of their field, those who or those who are show what they call exceptional promise to become leaders. There's few endorsing bodies for the sciences. It's the Royal Society, and they have 4 different routes, including a peer-reviewed route that looks at the applicant quite individually and determines whether they might meet the global talent thresholds. If someone meets that global talent threshold for exceptional promise, there's an accelerated route to settlement. Instead of 5 years, they can become settled in 3. And the qualifying criteria they can also either extend that permission to remain here for 2 further years to 5, and then qualify for settled status at that point, indefinite leave to remain. But the extension and indefinite leave to remain evidentiary requirements are quite low. They simply need to show that they're still endorsed, so they're still deemed to be recognized internationally, and they've done some work that they got paid something for. So I mean, it's almost to the point that they need to just still be breathing and in the UK. So it's quite a generous route if you can meet the requirements. The next, I think, most attractive route is the graduate route. It's not yet open. It is kind of a reintroduction of what used to be the post-study worker route. And so it grants either 2 or 3 year visa to any UK graduate who graduates from the summer of 2021. They'll be allowed to remain here and work for a period of time without the need to be sponsored in the UK. So it grants them time to acquire experience in their field, which I think is going to be very attractive, particularly for the younger workforce and for employers, because they will escape that immediate need to sponsor. There's also, for those who don't graduate from a UK university, but may also be young and interesting to the UK workforce, there's the youth mobility route. It's, again, a 2-year visa for nationals of certain countries, mainly Commonwealth countries, Australia, Canada, though Japan and Taiwan are also included, as is Hong Kong. And it may, in the future, open to European countries as well. We thought that it would in December, but they didn't do that. I presume it's because negotiations are continuing with Europe on trade agreements generally, and it might be something that the UK then decides to negotiate individually with each member state, because it's a reciprocity agreement. You know, just as a Canadian national can come here to work for 2 years, a British national can go there to work for 2 years. The age cutoff is 31 years of age, so anyone younger than 31 can benefit from this route. We also have representatives of overseas businesses. This is for companies that are headquartered overseas, as long as they remain overseas, can send a senior employee, but not a majority shareholder, to the UK to open up a branch. So that might be an attractive route for those coming to establish themselves in the UK. We have certain ancestry provisions, but for Commonwealth citizens that have a tie to the UK through a grandparent. That's the UK ancestry route, and it grants a 5-year visa. And then we've got family routes, so dependents of other categories. So the family member of a skilled worker could work, for instance, so long as they remain a family member and the main applicant remains a skilled worker. And then there's, of course, for family members of British nationals are able to work, as are the European nationals that we spoke of earlier, and their family members who are here before 2021, or that relationship existed before December 2021. And the last new route, which it's not yet open, is this British National Overseas visa for those who are resident in Hong Kong. So we understand it's going to open from the 31st of January 2021. Any British National Overseas citizen who holds that status by virtue of being from Hong Kong will be granted a visa they can choose. It'll either be 3 or 5 years, and they can settle in the UK after 5 years stay here. We presume that the requirement's going to be similar as far as residency and life in the UK test, but we're yet to see the rules. They can also critically bring family members, including adult children, who were born after 1997. That was when Hong Kong was, officially returned to China, and so it's more generous a route than, for instance, skilled worker route that only allows children under the age of 18 to come with their parents. So it is attractive in that aspect, and also, again, no sponsor is required. So, when considering sponsoring workers and when considering which route to use and whether to look further into those alternative routes that I just spoke of, in addition to the cost, there's also compliance aspects that sponsors and employers actually must meet in regards to right to work. It's multifaceted. The duties that are imposed by the Home Office and the British government on sponsors, basically, the government sees sponsorship as a privilege granted to employers that carries the requirement that that employer then assists the government in sort of policing the system themselves. And the way that the employers are reviewed and monitored is through compliance visits from the Home Office to see that they're meeting all of these duties that are imposed. Visits can they can be announced or unannounced visits. Right now, generally with COVID, the government is announcing every visit they're going to undertake. But in the future, we could go back to a system where they might just knock and show up on the door and then ask you a series of questions to see that you're meeting the requirements that they've imposed. So what are these duties? We have, I guess, the first are the record-keeping duties, which means that you have to keep certain records, which we'll go into in a minute, on every employee you sponsor. And then as well, once you've sponsored that person, you have to track and monitor their role, where they're living, whether they've moved address, that any changes of circumstances, and certain changes of circumstances must be reported generally within 10 days to the Home Office. Those tend to be around their actual employment. But it's worth noting that that there is this function that you have to undertake as an employer if you're sponsoring, and something that the employee has to understand too, because it is kind of beyond that normal relationship between an employer and employee. So it's important to keep everyone aware of these. There's also this requirement to cooperate with the Home Office, so just to disclose, when they request any information that's requested in relation to the employee or the role, or to you as a sponsor. And then there's specific duties, which we'll get into depending on which certificates are assigned. The sponsorship management system is this interface, this SMS, which you can allow certain people access to through level 1 or level 2 status, level 1 user, level 2 status. And it's a matter of just ensuring they're not sharing passwords, giving those passwords out, so that you know that the reporting is taking place, is being undertaken by the individual attached to that user ID. So the record-keeping duties, probably some of the most intensive administratively, are that you have to keep a prescriptive list of documents contained in Appendix D of the immigration rules for each worker. This is, passports, copy of the passport, copy of their visa, national insurance number, pay slips, evidence of an advertising campaign if you've undertaken it to go towards that genuineness. These are the sorts of things. They're all specific depending on the role and who's been sponsored. And list Appendix D will take you through that. They can be kept electronically or in hard copy, but you have to be able to access them and provide them on request to an immigration compliance officer. And then, just to keep in mind as I'm talking all of this, while the Home Office is exempted from GDPR requirements, you as employers would have to keep in mind how that data is being stored and accessed and who's accessing it to ensure that you remain compliant with those requirements, as well as your ability to provide this information to the Home Office. The reporting duties, which I've kind of touched on already, I'm just going to try to fly through these as quickly as possible. We only have a few more slides so that I can open it up to questions. But the reporting duties generally around, again, the work of themselves. If there's any changes to their circumstances, those need to be reported within 10 working days. That's even they're late, they didn't start the day you expected them to start because their visa is still being processed in China. Even that has to be reported. Or you've terminated employment. That is one of the circumstances that would need to be reported. Changes in your own circumstances. This particularly TUPE, if there's an undertaking, a merger or an acquisition, you sell part of the business, you're acquired by someone, that has to be reported in 20 days, and that can have an effect on your workers and how their sponsorship is continued. And then also a new requirement that you must also provide the police and the Home Office with any information that suggests a migrant is engaged in dodgy dealings. These reports, like I mentioned earlier, are made via the sponsorship management system by a level 1 or 2 user. And the Home Office, depending on what you've reported and when you've reported it, maybe you've missed your deadlines, that might trigger them to visit you or to make further inquiries of that individual worker. So cooperating and compliance duties we've kind of touched on already, but it's just cooperating with the Home Office as well as, keeping in mind your duties generally in relation to other aspects of law like employment, data protection, GDPR, and the prevention of illegal working. One of the larger areas that I think affects all employers, regardless of whether they're sponsors, are the right to work checks. You must undertake these in advance of employment, which is often something that we see doesn't quite happen that way. It's often a day or two after someone joins. They can be done manually or online. Something important to remember is that European nationals for the 6 months from 1st of January to 30th of June, you won't be able to ask them at that point if they've applied or in the process of applying for pre-settled or settled status, or even if they qualify for that, you would just be looking at their passport and or an ID card, and that's all that they would have to share. You can, of course, encourage them to apply for settled status or tell them that, from 30th of June they're going to need that, and they could maybe volunteer to provide you with evidence that they have applied, but you can't actually ask it. So what documents do you need? Generally, it's a passport. If it's someone who's not British or European, you'd also need to see a copy of a visa document, either an endorsement in a passport or a biometric residence permit. You can, with biometric residence permits, check immigration status online and keep a copy of that check verification that comes back from the Home Office. Otherwise, you keep evidence of the documents you've viewed by photocopy and signed and dated by the person who's seen them. I've kind of talked to you a bit about this already, but yeah, from up to the 30th of June next year, you're only required to verify that someone is European for them to take a role with you, even though they may not have settled status. You will be protected from any enforcement action if it later transpires that they didn't qualify or they didn't have the right to work because they came to the UK after the 1st of January. but the problem would become, I suppose, when they do get found, if that happens, there would be an abrupt ending of employment, which might, if they're in the middle of a crucial project, be detrimental to you as the business. So it's not a perfect situation. It's not a great situation to be in. But at the moment, the Home Office hasn't provided any clear guidance as to how that might be rectified. So from the 1st of July 2021, you will be required to ask any new hire at that time for evidence that they have settled status or pre-settled status. But just until that point, you won't be able to. I'm going to just go through these are specific duties around sponsoring workers. Just again, that when you're sponsoring them, you're verifying that these conditions have been met before issuing the certificate, and the records that you keep via Appendix D are designed to evidence and demonstrate that you've met all of these duties when assigning the certificate. But of course, the issue being that it's all looked at retrospectively by a compliance officer on a particular day, rather than prior to the certificate of sponsorship being assigned. I've spoken briefly about how the Home Office undertakes these compliance visits, these unannounced or announced visits, and they typically will want to interview the level 1 users, the authorizing officer, who is the person that has overall responsibility for the functioning of the license, generally the person who's kind of the highest level of executive HR. That's generally who the authorizing officer is. And they generally would also want to interview a few sponsored workers, check the files against the Appendix D requirements, and if there was a historic requirement to undertake a resident labor market test, see that those that test was properly undertaken and documents kept. Failure to comply, there's a series of things that the Home Office can do that generally involve suspending an employer's ability to sponsor workers, and this can have a knock-on effect if the license is actually revoked, of not only the ability to sponsor the particular worker that they've had an issue with, but any other worker that's being sponsored, their sponsorship would end and employment will have to cease. So it's quite significant, and the penalties can be quite draconian. For illegal working, for instance, the fines start at £20,000 per illegal worker. So it's important to keep compliance under review and in check. So I think through that was the whistle-stop tour of the new immigration system, the European settlement scheme, and kind of just compliance. I know that I've gone quite quickly, and I'm sorry again for that little coughing fit, but I wanted to leave just a bit of time for questions, and if we need to, I know that you don't have an immediate session after this session. I can stay on for a few more minutes to answer any questions anyone may have. So with that, I will stop the share. I see that there's, I think, only 4 of us in here. I mean, if you'd like, we can just, I don't know what you think, Aline, but if you'd like to just turn on your camera and unmute yourself, yeah, we can talk, because there's not too
because I think you joined a bit later, so obviously you should say, you can drop message in the chat box, but if you have any questions, just unmute and ask them. Maybe just a quick one from me, waiting to see if there are any others. What would you say, I mean, your experience with clients, what would you say is their main worry? Is it more settling the current employees they have now, or is it more the looking forward and the recruiting process in the future that you feel is a bit more complicated for them?
I think it's okay. So up until probably the last few weeks, it has been almost entirely focused on undertaking audits of current workforce and making sure that everyone was accounted for, that they had understanding of who might be affected by Brexit and who may not. But I think in the recent weeks, the focus has actually now started to shift, because many employers have now undertaken those audits. They have a handle on their staff and their workforce, and they know. But they've also now have plans, recruitment policies, projects starting in the new year and they're now beginning to focus on that Q1 of 2021. Do we have the staff? If we don't, who do we need? Can we get them here? There's been a lot of employers bringing forward employment start dates. People who were going to start on the 15th of January from maybe France or Spain are now starting the 15th of December to bring them into just using to kind of there's strategy. I think the focus now is on strategy. It was first, are we going to do we have all the records we need? Do we understand who might be affected by Brexit and who might not? Now it's, can we get in a cohort of people before the end of the transition period? And then it's, okay, from January 2021, if we don't have these people, how are we going to get them? It's kind of been that sort of thinking. And I think we're shifting towards we're very much focused on strategy right now. Can we get them in before the 15th of December or, before the 31st of December? And what does it mean to be resident in the UK? What do we need to do to show that they've been resident before the 31st of December? But also, for those that don't have licenses, we're also looking at making license applications to get those in place so that they're able to start sponsoring.
Yeah, well, I guess that was the other thing that brought to mind is, isn't it affecting more the smaller companies? Because I would suspect the larger one, they would have the sponsor license because they would hire from outside the EU before. So yes, it's more burden, but there's already some steps that are cleared, whereas the small companies, they were probably fine until now, and so they have lots of admin considerations.
Yeah, and I think it's not hitting them so hard because many at this point, I'm just thinking some of them that I've been working with, we have Europeans, because a lot of it is too, some of these are founded by European nationals. Some of them are run almost exclusively by Europeans. And for those, they're already here, we're okay, but they're looking at, well, what about next year when we have a new tranche of people that we want, we're looking to scale up. We want to scale up, or we want to grow the business, and we necessarily need this skill from this particular country or particular group. For those, I think, and the compliance duties for the smaller companies are quite onerous. And it's that's the consideration, I suppose. They're looking at licenses, but at the same time trying also to figure out how to meet the compliance obligations that are imposed. The government trying, though I don't see it happening. I don't see it really. It's not effective yet, but they're trying to differentiate compliance obligations because they're recognizing, the large multinational 400 to 500 staff in the UK, 1,500 worldwide, will have systems and processes to capture all this information and maintain these records without a human resource function actually having to physically, some admin person having to physically do it, where the smaller companies have that burden is much higher. And so the government is trying to create a kind of two-tiered regime for the smaller companies as opposed to the larger. But so far, it's not really being seen in the guidance documentation.
Yeah, and I guess for the government to enforce as well, because it's a whole new branch of applicants that you will have to check. So how can you do that? But yeah, well, it's a let's see then. I suspect. If there is no more question, I would say speak now or contact Meghan later. That will be probably my final word. I can't see any in the chat box. I think that will be my time for concluding that. So thanks a lot, Meghan, for going through that with the cough, because I know how awful that could be.
I'm sorry. And of course, I was fine all weekend going, it'll be okay, it won't happen. And of course it does. As soon as you start talking, I'm sorry, guys.
Oh no, I know that that's the sort of thing that could happen to me too. But no, I thought that was very exhaustive. Everything is there, so it's definitely the one to watch if you need to know what to do with hiring or with your existing employees post Brexit world. So on that note, concluding, as I said, get in touch with Meghan through Event app or later, just ask us or Rachel Bradley at Penningtons Manches Cooper, and we can put you in touch with her, obviously. This was recorded, so I would encourage you to share with your colleagues or anyone who would be interested in that, and we will share that on One Nucleus platform as well, because that's really definitely very insightful. So thanks a lot for everyone, and thank you, Meghan.
Thank you, guys. Thanks.
Thank you. Bye.
Bye.